Hello, everybody. I'm Spencer Mazyck, and this is the Bloomberg Law podcast. Joining me now to discuss several of the legal issues in the Occupy Wall Street movement is Bennett Gershman, a constitutional law professor at Pace Law School. Welcome, Professor Gershman. Thank you for joining us today. So before we get to the legal issues, and I know you're not a representative for the Occupy Wall Street movement, but I have to ask, do we have a sense of what their message is? Do the protesters have a goal?
The goal is to dramatize the disparity between rich and poor in this country. The goal is to dramatize the fact that wealth in the United States seems to be clustered in 1% of the population, and 99% don't enjoy that kind of luxury. They're trying to dramatize the plight of people who are out of work. They're dramatizing the plight of people who've lost their homes. They're dramatizing all of the issues involving income inequality and how the government apparently is not doing enough to repair that disparity. And in fact, the government, they claim, has been doing enough to make this inequality even greater through the bailout, for example.
Well, and you're absolutely right. According to their unofficial website, and I have to emphasize unofficial here, the group aims to expose how the richest 1% of people are writing the rules of an unfair global economy that is foreclosing on their future. Now, I understand that we all have the right to free speech according to the First Amendment, but as folks are beginning to congregate to spread this message, to what extent can police officers step in to try to break up or contain the protests?
Well, surely if the protest demonstration, for example, interferes with the orderly movement of people, cars, if it's loud, if it's raucous, if they're using bullhorns in a way that disturb the neighborhood, if they're engaging in violent activity, if they're doing things that are unsafe, the police can step in.
Well, then, but who's to decide what's unduly disrupting the peace? Because it sounds like that's what you're describing. I mean, I'm sure if you ask some of the residents of Lower Manhattan, they would say that any noise generated by the protesters is unduly disruptive.
Well, initially, it's going to be the police who make that judgment. Ultimately, it's going to be a court that makes that decision. But, I mean, the point about the First Amendment, and we're talking about speech, we're talking about demonstrations, we're talking about dramatizing a message, a political message, an important message. The point about speech is you can't say anything you want, any place, any time, under any circumstances. There are limits.
Okay, so what are some of the limits?
Well, some of the limits are that it has to be orderly. It has to be safe. It has to be, because we're balancing. It has to be done in a way that does not unduly interfere, for example, with traffic.
Is that what happened then on October 1st, whenever there was this mass arrest of about 700 protesters from the Occupy movement who were marching over the Brooklyn Bridge?
They were charged with disorderly conduct for interfering with traffic, essentially. That was, I think, the theory of the arrests.
Well, and I understand that arrest, though, had led to a civil rights complaint that was filed by 5 other protesters against the city. What are the allegations of that?
That's interesting. I mean, I think the allegation there is that the group notified the police that they wanted to march. Apparently, the police did not say to them, you can't march. And in fact, they claim, and this is just their contention, that the police led them onto the bridge and kind of escorted them along the way. Now, if the police did that, if that could be proved, then, this is sort of like an entrapment. The police set them up for the ultimate sweep and the ultimate arrests.
Yes, and I do know that the police have denied all allegations here with regard to that. But I understand also that some of the protesters are mulling over offers from prosecutors to dismiss the charges against them, but to do so 6 months from now. What's that all about?
This is a typical procedure in criminal court where the person is arrested for a minor offense. The prosecutor says, I will adjourn this case for 6 months in contemplation of dismissal. It's called an ACD, adjournment in contemplation of dismissal. And if after the 6 months the defendant stays out of trouble, the case is then dismissed and there's no record. And that's, as I say, a typical procedure that prosecutors use when they're dealing with minor offenses where the defendant doesn't have a criminal record, for example, and where they want to get, clean up the congested court calendar, because, there are a lot of cases in criminal court in New York, and, the prosecutor doesn't have the time and the resources to prosecute everything.
Right. So do you think, though, that some of the protesters who were arrested will actually seek trials?
I think they might want to, because, again, a trial might be a method of dramatizing the issue. The courtroom is always an arena that you can use for political purposes. My guess is the prosecutors don't want to allow them to do that, and they may just say, we're going to dismiss it, forget it, we can dismiss it. And if the prosecutor wants to dismiss the charge, there's nothing that the defendant can, I want to go to trial. No, I'm going to dismiss, I don't think that that's something that the defendant can really complain about.
Right. Okay.
So that's where we are.
We'll see what happens with that. But we've talked about, to this point, the First Amendment giving us the right to free speech and giving us the right to protest and assembly. But there are some who say that the one thing that the First Amendment doesn't give us the right to do, which is to pitch tents in Zuccotti Park, as the protesters have done. Does the First Amendment protect this sort of tent city that has formed in the park?
I would say it might. It might.
It might.
It might. And again, we're talking about speech that is not pure speech, where people are simply orally advocating something. We're not talking about pure speech plus conduct, which would be a march, a demonstration, picketing, something like that. We're talking about pure conduct. And setting up a tent city to dramatize this issue is conduct. But sometimes conduct can be speech and can be given the protection of the First Amendment.
But what's the speech, though, of the tent city setting it up?
The speech of the tent city is to symbolize the disparity between the rich and the poor. The poor people live in tents or in cardboard shelters. The rich live in mansions on Park Avenue. It's to dramatize that gap. And so that people who are living in a kind of a shelter like that suggests poverty, it suggests homelessness, it suggests unemployment.
Yes, but I understand that when the protesters began camping out about September 17th there, do you think it was their intent to convey this message of economic disparity with the tents?
I absolutely do.
Really?
I absolutely do. I think that was their intention. I've considered, the idea of the homeless setting up tents, for example, in Central Park. Now, that won't happen because Central Park is a very different venue than Zuccotti Park. There was an attempt to set up tents near the Washington Monument several years ago, and actually the Supreme Court addressed that case.
And with it saying that it was symbolic speech.
Well, that it was symbolic speech, but just because it's symbolic speech doesn't mean it's protected under the First Amendment, because again, you have to balance the interests of...
What are some examples of symbolic speech that's unprotected by the First Amendment?
Unprotected?
Yes, exactly.
Probably
spray painting and everything.
Well, let's do even worse than that. The most extreme example would be a terrorist act. A terrorist act.
Yes, of course.
A political assassination in order to dramatize your message. Now, that is the most horrendous extreme example, which would, of course, never be protected. But I'm saying that actions, conduct, can be the equivalent of sending out a message. And depending on the nature of the conduct, some conduct is far more heinous than other conduct. Setting up a tent or a cardboard shelter in Zuccotti Park doesn't seem to be that serious a form of conduct. It's not really bothering anybody. Okay, it's bothering people who want to use the park.
Right,
but again, you're balancing society's interests. You're balancing the right to dramatize your claim through this type of conduct.
All right. Well, we're going to have to leave it there. I don't want to cut you short there, but it sounds as though that the symbolic speech you're saying that the tent city might be protected under the First Amendment. So we're going to leave it there for this specific issue, but thank you for joining us and being with us today, for sharing your insight.
I'm pleased to be here. Thank you.
That was Bennett Gershman, a Pace Law School professor. So now we'd like to take a look at a different legal issue pertaining to the regulation of Zuccotti Park. For this, let's go to Eric Topor in Washington, D.C. He is the legal editor of B&A's Real Estate Law and Industry Report. So, Eric, as you know, Zuccotti Park is a privately owned public space. Let's begin right there. What exactly does that mean, and how are these spaces created?
Well, a privately owned public space is a creation of a New York City zoning policy from 1961, where the city basically decided that it would give certain concessions, zoning concessions, to developers who wanted more floor area, more buildable space, or certain setback concessions, and in exchange for the city granting those concessions in excess of what normally would be allowed under city zoning regulations, the developers would agree to set aside a certain portion of their privately owned space as a public park. And that's what happened with Zuccotti Park in 1968, when the original developer and owner of Liberty One Plaza, U.S. Steel, wanted to have setback requirements from the street that were less than what zoning required at the time. It made an agreement with the city that it would set aside a certain portion of their building lot as what now is known as Zuccotti Park.
So when Zuccotti Park was formed, though, the owners, like you said, Brookfield Properties, agreed to a set of rules for the park. Under those specific rules, then, are the protesters free to camp out indefinitely in the park?
Well, it's a little unclear. The agreement that set up Zuccotti Park really doesn't give a lot of guidance about what uses are allowed in the park. It just says the park must be a permanent open space. Now, a lot of these public spaces around the city, these privately owned public spaces, they are open 24/7, and Zuccotti Park is one of those. The only real rules of use that are set down is that the owner, Brookfield, can set reasonable rules of use that the public has to abide by.
Well, and it sounds like those rules that were created back when the park was formed were loosely defined, but were this a city park like Central Park, wouldn't there be clearly defined rules in that we would know that you couldn't camp out there and there would be hours of operations? Right.
So a city park, the situation would be totally different. City parks are not open 24/7 like Zuccotti Park is. They normally close at midnight or 1 o'clock, or some of them even later, from dawn to dusk. They're closed. And if protesters were to camp out in a city park, they would also have to abide by other regulations like getting protest permits, things like that. There aren't those rules for Zuccotti Park because it's not public property. It's privately owned, and Brookfield is the entity that sets the rules.
Well, and speaking
now,
of I was going to say, speaking of Brookfield Properties, I understand that they recently posted new rules for the park against camping, lying on ground, the park benches, and then also against using sleeping bags in the park. So can the owners at any time institute these new rules? And more importantly, though, would they enforce these rules retroactively against the protesters?
Well, again, there isn't a lot of guidance either from the zoning law that set up the park or court cases of whether or what process an owner of one of these parks has to abide by in order to change the rules. As you said, now the new rules, which were instituted while the protests were going on, disallow a lot of the activities the protesters are currently engaging in, including setting up tents and sleeping there. It really isn't clear what retroactive effect that has. Now, the city, the mayor's office, and the police department have said basically it's up to Brookfield to declare the protesters trespassers. Brookfield themselves can't evict the protesters, and the city can't unilaterally decide to evict the protesters. What would have to happen is that Brookfield would tell the protesters they are in violation of the park's rules as are currently set, the new rules, and if the protesters didn't disperse, then Brookfield would ask the police department to evict them because they are trespassing.
Okay, well, unfortunately, Eric, we're out of time, but I have to say that with this movement spreading to 1,500 cities across the nation and around the world, there are bound to be many more legal issues for us to discuss. Thank you very much for sharing your insight with us today. Eric Topor, being a legal analyst and editor, and again, our thanks to Professor Bennett Gershman of Pace Law School. For more information on this or other topics, log on now to BloombergLaw.com. Bye, everybody.